Everybody's Christopher Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk to you about the 3 components of a valid will. The reason I want to talk to you about that is because we've had some probates come in and the wills have been less than desirable. And I want to just talk about it so that everybody kind of understands what a good will looks like, what makes up a good will, and what makes up a bad will, right? Before I get to that though, if you have questions about this or anything else related to estate planning or probate, and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. Okay, 3 components of a valid will. So there are really sort of, okay, so here it is basically. Step 1, there's really more than 3. I'm just going to give you all the ones I can think of off the top of my head. And then I'm going to tell you what makes them difficult when you're trying to go to probate. So first of all, it needs to be the expressed intent of the person that wants to write the will, okay? Typically, you identify your family and you identify where you want everything to go. That's about really all you need to do in a will specifically. You can name a personal representative. You can say that you don't want non-intervention powers. You can do some of these other things, but those things aren't specifically required. Those are just things that we put in to make the process smoother. It really just needs to be express your intent on where you want your property to go when you are gone. It needs to be signed by the person that is making the will. And in Washington State, at least, it needs to be witnessed by 2 independent people to like I literally see them sign. Those witnesses at the time they sign are saying that the person that's signing has the capacity to sign, so they understand what they are signing, and they are not signing under duress. Someone's not pointing a gun at them. Someone is not putting sort of outside pressure on them to sign this document. Those are the things that the witnesses are attesting to when they sign. Those are also, by the way, the ways that you can contest a will. That it's not signed properly, that the person lacked capacity, or that the person was under duress. Those are the 3 ways that you can contest a will. So if you have those elements, typically you're going to have a will that passes the smell test with a court. Here's the problem though when it comes to probate, when it comes to the will at the end. When we create our wills, we always create an affidavit that goes at the end of the will. The affidavit is signed by both witnesses, it's notarized, and it basically says, I am saying under the penalty of perjury that this person signed with capacity and they were not under duress. The reason that you create those is that becomes the testimony that the court needs to validate the signatures on the will. The signatures themselves are not enough for the court to validate the will. They need the independent testimony of those witnesses at the time the court is evaluating the will to make sure that it is indeed valid, that the witnesses do indeed exist, and that the requirements for a valid will have been met. This is where we have been, from time to time, we'll see things not work out right. There's no attestation, there's no notary that has validated the identity of the people signing, and so the court has problems with that. When that happens, we have to go track people down, basically, if we can. If we can't, then the will is potentially invalid, and we have to go pursue other routes. So that's how you do it. Okay, hopefully this made sense. If it did, if you like this, hit the like button. If you're someplace you can subscribe, do that. If you have questions or comments, leave them. I will answer them. And if you have questions about this or anything else related to estate planning or probate, and you want to talk with us over the phone for free, you can do so by going to cmslawfirm.com. All right, that's it, everybody. Thank you for your time. I am Christopher Small, the owner of CMS Law Firm. We do estate planning, we do probate, we do it well. Again, thank you for your time. Thank you for your attention. I appreciate you, and I will talk to you again soon. See ya.